Right, good morning to all of you. Let me suggest that you put your mic off so that you only put it on where you need to make a contribution or raise an issue so that we don't get the feedback coming from your end. Let me also remind you that this is being streamed live by YouTube, so whatever you are saying is not just within here. It's on the whole wide web. We have to be mindful of the background. Lily, you have to.
Hi.
Yeah. Okay. So first and foremost, some of you were expecting me yesterday. I explained my situation to you. Apologies. I have a couple of you who have been reaching out that they are scared, they are stressed, a lot of anxiety. Of course, legitimately so, around this time, you can be anxious and all that. But as we have reminded you before, there's nothing for you to really worry about. And having just today being the 6th of September, having just about 2 days to go, I want to believe that in terms of knowledge, you have done the needful by revising things that you are supposed to have revised. I mean, of course, if you haven't even done 100% revision in each of the modules, if you've done 80%, it's still not too dangerous. Of course, one who have wished that you're able to look at every topic in each of the 6 examinable modules: institutional law, law of contracts, Ghana legal system, land law, criminal law, and then the law of torts. Yeah, so that is the first point. Of course, the second point is that just barely 48 hours, if I'm not mistaken, for you to do your exams. If this is not time, of course, you cannot read everything now. You cannot read all the 6 subjects, all the topics in each of the 6 subjects in 48 hours. That is practically impossible. My suggestion is that if there is any topic which occurs to you as not having been looked at since you started revising, it is wise at this stage to actually to revise, as it were, yeah. Me try there online. We have it for a while. Thank you. Okay, all right. Yeah, so if there is any particular topic which maybe it comes to your mind and you panic a little bit because you haven't looked at it or you don't understand it, then my suggestion is that you need to go and look at it, because assuming the question were to come from there, what your instinct is telling you is basically that you'll be found wanting. So you follow your instinct and then you go and look at that topic. And if you still have some difficulties, I think within 48 hours, you can seek assistance from me, any lawyer, any law teacher, or anybody. that you come across. So that is one of the practical advice I would like to offer to you in that respect. Now, coming back again at this stage too, I have some friends who ask me, my Lord, can you give us some pointers? And I told him that anybody who will put his hand on his or her chest and tell you that learn topic A or learn topic B, because there's a high degree of certainty that question is going to come around that. Respectfully, I would like to suggest to you that the person is deceiving you, okay? Unless the person has indulged in some criminality by going to break through wherever the question is and then steal the question, which is an illegality. Otherwise, apart from one person who is putting the paper together, nobody knows the question. I don't know, nobody knows. So get that right. And that is why I cannot tell you any particular topic. And I just always try to stimulate a general discussion, A to Z, across everything. And I keep also telling you that once you have that kind of like a general revision, regardless of where the question will come from, even if you're not going to get 50 over 50 in a question, you'll be able to do more than 25, right, over 50 in that question. And once you get that, you've already crossed the 50% threshold, and you'll be in a comfortable lead if they are going to draw the line to pick those who make it to the law school this coming academic year. Yeah, so that is another practical advice. Then again, just summarise, if you look at the trend of questions, one may argue that if you study the questions carefully, whoever is setting the question for them or whoever put the questions together, sometimes you get the sense that the examiner tends to look at some contemporary issues, like that is some of the current happenings, which have got the legal dimension or legal flavor, and try to weave a question around that. Therefore, assuming that you have heeded the advice I gave previously and you have done all the general revision, so just the last minute, you are trying to figure out what particular topic or topics should I be anticipating. I will probably suggest that you could also look at some topical or current issues, and this is a law paper. It's not just ordinary paper. So you look at the current issues and you begin to ask yourself, how does this particular fit into law, or what is the legal dimension or the legal aspects of this particular issue, and so on. So that way, you also assure yourself that assuming the question is going to reflect current happenings or issues, you will be prepared because you have actually thought through that. On the other hand, if the question is not going to come from any of the current happenings, just any standard law exams as during the LLB days in the various law faculties, you also not be caught pants down because you have actually done the general revision or preparation, as it were. Good. Now we come back to another practical thing. I've told, those of you who have been following some of my sessions, some of these things I have shared them with you before, but since we this online thing is not like a first class, students keep changing, and also depending upon people's stress or anxiety level, they tend to forget some useful tips, which have been shared before. So as and when we have like this encounter, we'll keep on reminding ourselves about some of these things. So maybe just before we probably share ideas, another practical suggestion or I like to suggest is that when it comes to answering questions, okay, please understand the question first. I can tell you on authority that examiners do not hesitate to give students 0/50, where a student has deviated. And why is it so in this type of examination? Now, as I have told you before, this examination you are doing is not the regular examination, right? It's not towards award of degree, award of any certificate. In which case, the argument will be that, okay, has the student been able to achieve the intended learning outcomes or the objectives for the particular course? If you get some evidence that the student has attained that, then you don't have to be too harsh. Give some credit for the student's effort. Now, that is perfectly the case where you are dealing with the school setting, right? Before you go to your LL, before you are dealing with the school setting, that is perfectly the case. But where we are now is different. And why do I say it's different? It's different because this is selection exams. The assumption is that all of you have got LLB, right, or its equivalent. But we cannot take all of you into the law school, having regard to the current infrastructure deficit and so on. So some will have to be dropped. So the question is, who are we picking and who are we dropping? And that is why it becomes important for you not to deviate. Because if you deviate, you are giving 0, or you are just giving just 1 or 2 over 50, and then the examiner will move on. And that is why I have suggested that don't rush to just write anything. Before you start writing the answer essay on the answer booklet, make sure you understand what the question is about. That's the first thing. And having understood the question, if it is a problem, let's start from essay question. If it's an essay question, I've told you, having understood the question, okay? I don't know whether they allow you to write on the question paper, but assuming probably in most exams, they don't allow students to write on the question paper because of the fear of abuse. Maybe a student may pass his paper to another person, like examination malpractice. So most examinations, students are not allowed to do that. So that is fine. And for that matter, I would suggest that maybe the first page, okay, the first page of your answer booklet, you can just write something, the rough work, okay? You can just write rough work. And then, having read the essay question and having understood it, right away, start putting down all the points which come to your mind. When you're putting down the points, don't waste your time to worry about the order, right? As to which one comes first, no. As the points or the ideas come to your mind, please jot them down. Because if you don't do that, some important points may escape you. But as soon as they come, just jot them down at where you've written like the rough work. Now, when you have done jotting down the points, read the essay question again. And having read it again, you come back to look at the points, and then you try to arrange them. Which points will need to form part of the introduction, and then which points will be this. And there has to be some logical order, okay? There has to be logical order. Essays usually may be responded to in a form like a storytelling. And if you are telling a story, it has to be like systematic, logical, and chronological, that kind of sequence. So that is important, so that when your answer is read, there is that kind of coherence, right? Your examiner can understand what you are trying to say. So that is important. So structure is important. Even where, as you said, the essay probably like half points you have to discuss. It will not be out of place if you may also like a subheadings, okay? Assuming the question calls for that. But ultimately, an essay must have a good introduction. And then, as we often said that, they can't say that agrobeswa is free anopa, isn't it? So if you are going to have like a meaningful game, you get a sense or a hint of it early in the morning. And we also told that a first impression matters. The introduction is what's going to give your first impression to the examiner regarding the what you are made of. I'm talking about the paper, right? What the paper is made of. So the introduction must be well written. Don't beat about the bush, okay? Examiners have told us that students beat about the bush, like writing unnecessary things. The introduction is not just for you to play games, right? Whatever you are writing there should count as part of answering the question. And again, remember that you have time. The paper, you are supposed to, you don't have all the time in the world to do one question. And for that matter, you don't have to be writing unnecessary things in the introduction. So keep that in mind. I mean, if for nothing at all, in standard terms, introduction will include letting us know what you understand the question to be inviting you to do, and then giving some kind of like a roadmap in terms of what you propose to explore or discuss in order to respond to this, the question is in, and so on and so forth. So, and then, of course, as we are told that if there is a need for any key concepts or point in terms of definition or whatever, to throw light on, because it's going to form an important part of whatever you are discussing in the body of your answer. That will also have to be done as part of the introduction or immediately thereafter, as it were. And again, let the paragraphing stand out. Don't let your examiners struggle, right? Now, you're reading somebody's paper, and then you have to hold it, like this, close to your eyes, in order to try to get to know what the student is doing. I don't think that is good enough. And as I've told you, you want to put up your best show so that you make a right impression. And then the rest of your answer will be read by the examiner in that kind of like a good spirit, okay? And give you the necessary credit, which you are supposed to get. So pay attention to that. And again, language, okay? Mind you, this is not entrance examination to University of Ghana or UCC or KNUST or IPS, UPSA or any other law faculty or Presby University. This is entrance examination after having been awarded LLB to go and do the professional legal education, become a lawyer. And for that matter, we expect a certain language proficiency, right, from you. There are certain, horrible language mistakes if you make those mistakes, you make your examiners angry, because someone who has gone through LLB, you should be able to write meaningfully. So please pay attention to that. And that will also include your spelling. And don't take your social media, language, right, into these exams. What I mean is that the kind of thing you write on the WhatsApp, Telegram, Facebook, and so on and so forth. Sometimes we use a lot of slang, a lot of various shortcuts of writing. Make conscious effort not to let that follow you into writing your exams. So that is important. And if you manage your time well, so that you're able to finish your answer within the allotted time, and the portion of it which you have devoted to the writing, you need to read through your answer. Sometimes when you are writing under pressure, the brain works faster than the brain works faster than the hand. So yeah, class, we are call you before I go. All right, thank you. The brain works faster than the hand. So there are things which your brain will bring up, and your hand may not be able to put it down. And that is why it's wise to go back and read your answer, so that certain omissions, you can supply them. And then again, let me say, like authorities, right? That point has come out before. Authorities, the use of authorities, assuming it's a constitutional law question. We don't know, but of course, one will say that probably for a number of papers, we tend to have one constitutional law question, but we don't know whether this year will be like that. Last year, there was one constitutional law question, the previous year, and I think the year before that or so. But we don't know whether the consistency in bringing a constitutional law question will continue. Or one will argue that maybe constitutional law and Ghana legal system, okay, they stand in one category. So you get a question around constitutional law or legal system, assuming that trend is followed. So you are doing a question, let's say from constitutional law, let's say typical like an essay question. We need to use authorities, okay? And authorities here will essentially include provisions of the Constitution. Now, where you do not remember what article, let's say that Article 75 of the Constitution is saying, okay? But remember that there's a provision in the Constitution that where Ghana has signed a treaty or ratified a treaty, it needs to be domesticated before it will have like a legal effect and all that. Don't write Article 49 and say this, because once you put this Article 49 there, it will negate the correctness of the statement or the proposition that you have made. Because if you go and look it up in Article 9, we will not find it there. So let's suppose that that is in Article 75. But because you put Article, let's say 49 there, you've spoiled whatever you said. But if you simply stated that according to the 1992 Constitution, even if you are not going to get like the full marks, which probably is allotted, you will get some of the marks. And it's better than you writing a wrong article against a correct provision, and then you are marked wrong for that. So be mindful of that. And again, where there's a provision, and you have like a Supreme Court decision, the constitutional provision is first, before the Supreme Court decision, okay? Supreme Court decision is a case law. So if you have like the provision of the Constitution, that is the first authority. And then you add the case law, which often interprets or applies as it were. So remember that. And someone also said that should we do anything for the authorities to stand out? My answer is that yes, if you can write the authorities boldly, right? Or even underline, it will not be bad because your examiners are marking under pressure and they need to, when they take your script, they need not spend unreasonable period of time on just one script, especially when the examiner probably has a couple of scripts to deal with within a short period of time. And that is why you have to also assist those who are going to examine your answers and all that. So keep that in mind. Of course, we've said a couple of things about problem-based question, okay? Don't forget the IRAC. If you have a problem-based question, you don't go by the IRAC. That is, identify area, raise issues, take the issue one after the other, and state the relevant principles, and then the corresponding authorities. And then you do the analysis. The analysis means that you look at the principle that you have stated in relation to the facts from the question, and then you want to find out whether the facts you have in the story actually support that principle, and then use that to answer the issue. The issue is a legal question that you have formed. So you do that for all the issues that you have, and then when you are done, you draw one big conclusion. So that is the standard way of going about problem-based question in law. And if you don't do that and you just do it anyway, you just start talking, you'll not be marked wrong, but you'll be marked down. You'll be marked down in the sense that marking scheme will usually allot marks to the various components. So if you just started jumbling and mumbling everything together, you are going to be given a global score or global award of marks. And that will not be in your interest because you end up getting less than what you have obtained if you had actually gone systematic as is recommended. Yeah, so let's keep that in mind. And I think that the other final practical thing I'm sharing with you is that respect the time. If I'm not mistaken, I think the paper is 90 minutes, isn't it? Or is it 90 minutes? Or 2 hours?
Yes, sir, 90 minutes.
90 minutes, okay, good. So you have 90 minutes, and usually, I think you are supposed to do 2 questions. So I would suggest that you use 5 minutes. Use 5 minutes in understanding the question, planning your answer, and then you use maybe 37 minutes to write the answer, and then use 3 minutes to review the answer. Because if you have actually planned you've understood the question, and you've planned the answer well, developing it should not be difficult, okay? Developing it should not be difficult. And be able to develop your answer plan into a full-fledged or meat answer, let's say within 35 minutes or 37 minutes, and then you are still left with 3 minutes. And then you use the 3 minutes to go over the answer, cross the T's, put the necessary dot there, and then if there is any error you need to rectify, you do that. And then don't deepen your answer. If you make a mistake, you can just cross it, right? You can just write through. and then you do the proper thing there, so that your answer will stand out neatly. And then in terms of writing, what you call the legibility, right? Legibility. Your answer should be legible. That is, your examiners should be able, of course, I don't have a great handwriting. Some are endowed with great handwriting, which is good. But at least what I know is that I make effort for what I am writing to be legible, so that somebody can read it. You see, that is the point. No matter how great your answer will be, if it cannot be read by the examiner, what is the point? As somebody will say that, what will it profit a man if you gain the whole world and then you lose your soul, isn't it? So what will it profit a student if you've written all the correct answer, but the answer cannot be read? There's no point. If it cannot be read, what you have read is known to you alone. Your examiner cannot read it. So you might have written, let's say, the most perfect answer, but because it cannot be read, and you cannot get the credits or the marks which is supposed to be given. So let us keep that in mind. So let's make effort. And some students also develop the habit of, I think they write and then they'll leave one line. Okay, I think some scripts, not from your, just from some master students somewhere. You look at their script, they write one line, and then they leave a line. Okay, it's not, if that is what you think will help your answer to be legible, that is fine. Otherwise, one will argue that you don't need to do that. All that you have to do is to leave a paragraph, as it were, so that there's some kind of proper layout to help the reader of your answer. So let us keep that in mind. And let's also look at this, especially students who either they don't plan the answer or they will plan it, but at the time that they're planning, a very important point escape their mind. And when they have finished concluding the answer, then that point will actually flash or come back to them. What should they do? Okay, my advice is that it will not be wise for you to cross out your answer. Okay, no, what you've written is good, except that there are some other important points which ought to have gone into your answer. But unfortunately, your memory did not assist you at the time that you needed them. And they have come, as we are told, better late than what? Never. So where you find yourself in that situation, you can, at the bottom of the answer, you write either maybe NB or additional points, and then you put that there. And once it's on the paper, definitely your examiner cannot take his or her eye off it, assuming what you have put there falls within the points set out in the marking scheme. You will definitely be awarded some credit for that. And it's better than you not putting it there. So let us keep that in mind. Okay, so are there any, before we come to do some substantive, maybe Q&A before I will leave you, and are there any practical issues any of you are facing, you want us to look at? And then if there are some challenges you are having, we can also bring it up and then we think through together.
Hello, sir.
Yes.
All right. So flowing from the conversation you just had with us, that wonderful conversation, where because we are writing legal papers, authorities become very necessary.
Yes.
How about in a situation where you are given a question where the question seems to suggest that you are to do an appraisal of a historical event? For instance, if a question is suggesting that the robustness of the Fourth Republic is as a result of the processes that the 1992 Constitution went through, and therefore do an appraisal of the stages of that processes. In such a situation, how do you support your answers with provisions in the with statutes and authorities?
All right. Okay, good. So going by the hypothetical question that the robustness of the 1992 Constitution, which has made it survive, I think, 30 years of democratic experiment and all that, is as a result of its checkered history or something like that. Discuss or praise a statement. Is that something you're looking? Is that something like that?
Yes, sir. Yes, sir.
Okay. So if you have, assuming you have a question like that, this is an essay question. And as I said, we should understand what the question is asking. And the question is, if you look at it, it's straightforward, telling us that, yes, it is a fact that the 1992 Constitution has actually stood the test of time, comparing it, if you compare it with the other constitutions that we've had before. So I think it's almost 30 years or thereabout. So 1993 to 2023, that's 30 years, if I'm not mistaken, yes. And the question is saying that that is so because of very difficult history, which preceded the 1992 Constitution. And you're asked to appraise, that is, examine, evaluate, or assess. Is it true? Is it true or is not true? Explain. That is the point. And again, is it also true that the Constitution is that robust, and that is why it has stood the test of time for the past 30 years? So, having understood the question in the way that we've endeavored to do, as we have suggested, you need to actually put down your thoughts, the points as they come to you. So what are some of the points? So what are some of the points? We just keep randomly. What are some of them? Okay. Mechanism for defense of the Constitution, Article 3. You look at the processes before the Constitution was adopted. So the National Commission for Democracy, the Committee of Experts, the Constituent or the Assembly, that's the Consultative Assembly, referendum, various military interventions, which they read 3 other constitutions and all that. And then you also look at the multi-party democratic experience since 1993. freedom of expression, media freedom, and things like that. So you put all these points down. Then, when you have finished putting the points down, you try to arrange them in a way. Of course, I'm not saying that these are the only points, but at least there are some of the points which I certainly will be needed in thinking through our friend's hypothetical question that he brought up. So you arrange them in the logical order, in a way which will let the answer make sense. That is the point. And developing them. But then his direct question is that the suggestion that authorities should stand out in answer. How would that apply in a question like this? When we say authorities in law, as you know, we are talking about the legal support for proposition or assertions which are made. Okay, and of course we have the the hierarchy of legal norms. We know Article 11 and so on. So those are like the kind of authorities that we are talking about. But if you are doing historical discussion and you are not using any particular legal rules, then that is different. But again, we still come back to the suggestion that you need to have maybe some subheadings, okay? You can have some subheadings in your answer, just like what the kind of hypothetical question our friend brought up is a question which you can conveniently do what do you call it? You can conveniently do your subheadings to help people to be able to follow what you are doing. So let's keep that in mind. Okay, any other? I don't know whether that assists our friend who brought up the question.
Yeah, yes, it does.
Okay.
Just a follow-up.
All right.
Yeah, just some small confusion in my mind. So,
and those who are not hurrying up, I have I need to travel somewhere. So, in about it's now, let's say 12. Probably maximum 40 minutes. I will have to sign off and then continue to do some other things. So if you have anything, you have to bring it up. Okay, yeah, let's go on.
Yes, sir. So in such a question, assuming as I do not have the constitutional and statutory provisions, but then I have writings and sayings of authorities such as Professor SKB Asante and other people who have written or spoken about the constitutional processes, and I cite their work. Would that be authoritative enough for a legal paper such as this?
Oh, why not? You see, as I said, authorities legal support. So if the answer you are writing is something of a historical discussion, and if you have what you call the writing of scholars, right? Writing of scholars relevant to what you are talking, like articles and other monographs and so on. Yes, they are authorities. The authorities for that particular point that you are making. For that particular point that you are making. Yeah, so that can be cited.
Thank you, sir.
All right. Any other question?
Hello, Doc.
Yes, Thelma.
Yes. So please, my question is, it has been suggested that because of time constraints, sometimes after, let's say it's a problem-based question and you lay out your structure, area of law issues, it's been suggested that for the rules, you can just list the relevant authorities of course, starting from the Constitution, and then in the application, that is where you lay out the specific rules pertaining to the details, pertaining to those you have listed, and then subsequently apply. That is what has been suggested because of the time constraint, and I want to find out if that would be a reasonable way to go about it.
All right, thank you very much. When it comes to the problem-based question, I think this point we've made it before, but we're going to reiterate it in the light of the question which has come up. When we are doing the IRAC, use of authorities, feature 2 times. The first one is where you state the principle of law, the proposition of law, and then you are required to indicate the source of that principle or that proposition of law. Where did you get the principle or the proposition of law from? Is it from a provision of the Constitution? Is it from an act of parliament? Is it from a decided case, or what? Indicate it. Now, when you indicate it at that stage, you are not required, and you don't have to actually, I should say, tell us anything about that case, apart from you citing it as a support for a certain statement of law, a certain proposition or principle of law. Okay? You don't have to give any other information about that case at that stage. Now, when you are done stating the principle and then you are doing the analysis and application, that is, you are trying to demonstrate that the principle of law you have stated is actually satisfied by the particular fact pattern or scenario before you. Then, if in your considered view, a particular case, that's a decided case, if the material facts are the same or very similar to what you have on hand, and for that matter, you think that whatever conclusion that you are arriving at on that issue will find a good support in that particular case whose material facts are the same or similar to what we have on hand. Then you go ahead and tell us briefly what happened in that case and how it was actually concluded. So that is the difference. But when you are outlining the principles, you just put the authorities there in some kind of like a bullet, but you don't need to tell us anything about that at that stage.
Okay, Doc. So just to be sure that I have got it correctly, one can state or list the authorities, and then the principles in the course of analysis, the person can state those principles and then apply accordingly.
Yes.
Okay.
Yes.
Okay. Thank you so much.
Very well. Any
sir, follow up to our lady's question. So by listing the principles and the rules, we're talking about, say, section this, and you paraphrase what is in that section, or just say section this of this act, and then you move on. Then you rather go and use whatever that section says in the application section.
Okay, so let me give you this example. So let's say it's contract, okay? Let's say it's contract. I think last year there was a question on contract. I think so. I think a year before, but I don't know whether this year there will be a question on contract. But let's suppose that you are talking about frustration, the effect of frustration. And you want to say that where a contract has become frustrated, expenses incurred in performing the contract before it was frustrated may be recoverable. So that is a statement of law, proposition of law. Where did you get that from? Then you can just make a colon, or you can make a dash, or you can just full stop, say see section 1 into bracket 3, section 1 subsection 3 of Contract Act 1960 Act 25. So that is the authority for that. Okay, that is an authority for that. Or if I'm saying that where a contract has been found to be illegal, the court may allow money to be recovered under such a contract in order to avoid unjust enrichment. So this is a statement of law. Where did I get that from? I got that from the Supreme Court decision in the City and Country West Limited versus Accra Metropolitan Assembly. So that is how it is done. The question, I don't know if that assists you.
Yes, sir. Yes, sir. It does. Thank you. Just an appeal, sir.
Okay.
In one of your slides on your YouTube, I think from last year or last 2 years, I stand with, I'm not so sure. You did a tutorial on how to answer IRAC questions, and in your tutorial you had a Word document that you used, and you even had sample question and how it's supposed to flow. I don't know if it's possible for you to share that document with us, if it will be possible. Just a plea.
Okay, so if you are, we have like a couple of platforms, or if you are not on the platform, you can go to Telegram and then look for, I think, Ghana Law TV. If I'll put it there too, so that you see it. But if you're on any of the platform too, when I'm able to retrieve it, I'll put it there and then you see it.
Thank you, sir.
All right. Yeah, so any other issue? I know at this stage, all of you are in top shape, ready for 8th of September. Should I assume that there's no question or anything bothering your mind?
Hello, Doc.
Yes.
Doc, with all respectfully, are you able to just lead us through the topical issues we should concentrate on? Because it stands, we are reading wide, but if you're able to say, look at this, the topical ones, then we contrast and compare with what we have already. Thank you, my lord.
Mr. Mreku, that is a good invitation. Respectfully, I turn down your invitation with all humility.
I agree, Doc.
Thank you. Juliana, any question? Lynette was here. Lynette, any question?
Hello, Doc.
Yes.
Yes, please. I think I sent you a question, but I did not get any response earlier.
Really?
What does it mean when it is stated that a third party to a contract cannot invoke Section 5 of the Contracts Act to rely on an exemption clause to escape liability?
Oh, right. Okay. Good. So, what they call the Purposive of Contracts, which has been modified by our contract, as you rightly said. In the Purposive of Contract, as you remember, a case of Twaddle and Atkinson, Garton and Poole and so on, let us know that where you are a third party or a stranger to a contract, in the sense that you provided consideration, you cannot enforce any right or benefit under the contract. And you saw the case of Dunlop pneumatic tire against Selfridge, how it created some exceptions. The exception being like agency, trust, restrictive covenant, and probably like the easements and yeah. So those are the only situations at common law where you could go around the probity rule. And then there have been statutory intervention, especially in our part of the world, per section 5(1) of the Contract Act, that if you are a named beneficiary, right, or you are within a class, a designated class of beneficiaries, and a particular contract, then despite the fact that you are not a party, by reason of being a beneficiary, you will be able to enforce it. And we are also told in the same Contract Act that exemption clause is not applicable. And you know, exemption clause is where there's a contract between two parties, and there is a provision to the effect that when one person is involved in certain types of breaches, he or she cannot be held liable. Let's put it that way. Or if he's involved in certain acts, those acts will not be considered. Ordinarily, had it not been for the exemption clause, they will have been considered as breaching the contract. But because of the exemption clause, they cannot be held liable for those actions and so on. Now, that does not apply to third parties, in the sense that if there's a contract between A and B, and A is entitled to exemption from certain liability. If C is outside, C ordinarily should not be able to enforce that exemption clause. So that is the point. It's different where there has been assignment, okay? Where there has been assignment, if, for example, A has transferred his rights and liabilities in the contract with B to C. And of course, assignment will definitely have to also be done with the knowledge and consent of the other party. So once B has accepted that yes, C can step into the shoes of A, so that A will drop out of the picture, and C will now be in the stead or in the shoes of A, and be able to enforce all rights and bear all obligations which A will have been entitled to. Then, assuming there's an exemption clause, by reason of that, C will be able to enforce it against B, so that where C is involved in certain actions which ordinarily would have amounted to breach, had it not been for the exemption clause, he will be able to escape liability, as it were. Yes, so that is it.
Hello, Dr. Rapa.
Yes.
And please, this is Lynette.
Yes. Anything you are learning you want to share with the group?
Yes, please. I have a question in relation to defense of the Constitution, Article 3.
Okay.
And please, when you read Article 3, Clause 4, it says that all citizens of Ghana shall have the right and duty at all times to defend the Constitution and to do all in their part to restore this Constitution after it has been suspended or overthrown or abrogated. But then if you look at Clause 5, it says that any person or group of persons who suppresses or resists the suspension, overthrow, abrogation of this Constitution, as referred to in Clause 3 of this article, commits no offense. And then if you read downwards, it says that where any person has suffered punishment or loss as a result of resisting or suppressing the suspension, the person will be awarded. Please, any person as used in clause 5, is it in respect of just citizens or foreigners who also contribute to the suppression or resisting of the suspension or overthrow, such that they would also be entitled to the award?
Right.
Yes.
All right, thank you. That provision has not been interpreted. However, Article 2 has been interpreted. The person there, we have a number of Supreme Court decisions which has interpreted Article 2, which says that any person who alleges that anything done is in contravention of the Constitution and so on may bring application for declaration to that effect. And that person has been interpreted to refer to both natural and juristic person, but they must be citizens.
Yes.
It must be like Ghanaians, isn't it? And
yes,
that's also apply, unless, of course, if you are using like purposive interpretation, okay? If you are using purposive interpretation, an argument could be made that the person under Article 3(5), as you rightly quoted, should not be limited to only Ghanaians, but any person who will help to restore the constitutional order. Because what Article 3 is trying to do is to preserve the constitutional order ordained by the 1992 Constitution. And that is why it says that we should do everything to resist any attempt to overthrow the constitutional order. And where it is overthrown and you work hard to restore it, and you even suffer any injury and so on, you're supposed to be compensated. Then the argument to be that if non-Ghanaians, right, non-Ghanaians have actually worked hard. Let's take the scenarios in neighboring Africa. You take Mali, you take Niger, and so on. So let's use the Niger one. I think is one of the most recent, and probably the Gabon. But Gabon is, I think, the Central Africa, not West Africa. So let's do like Niger. So we take Niger, for example. Just for argument, let's assume that the constitutional arrangements in Niger are the same as we have in Ghana. And here is the case. The junta, that is the military, have actually overthrown the constitutional order. And so you get maybe other people, probably from Nigeria, who go to Niger, and they are able to fight and remove the junta from office, and they are able to restore the constitutional order. And let's say that in the process, some of them died and they've got dependents, wife, family, and so on. Now, if the constitutional arrangements of Niger, assuming just for the sake of discussion, are the same as what we have in Ghana, then in terms of Article 3, you ask yourself, does it make any difference whether those who help to restore the constitutional order are Ghanaians or non-Ghanaians? In my, of course, this is not the pronouncement made by the Supreme Court, but in my considered view, aided by the doctrine of purposive interpretation, or the approach of purposive interpretation of the Constitution, one would like to think that the most important thing is restoration of the constitutional order, right? And for that matter, the person should be beneficially interpreted to encapsulate anybody who will restore the constitutional order. But as I said, this is not pronounced upon within the interpretation mandate of the Supreme Court. But I will not be surprised if the person as using Article 3, which Thelma has brought up, is interpreted different from a person using Article 2. I'll not be surprised if that were to be done, especially so if one considers the fact that what is pertinent is the restoration or preservation of the constitutional order. And if there has been any attempt to overthrow it and anybody succeeds in actually restoring it, should we concern as whether the person was a citizen or not a citizen? What are your thoughts?
Yes, sir.
Yes.
So I'll just share my thoughts and then ask a follow-up question to the lady's question. Or maybe I should ask the question first.
No, let's clear this and then so that we don't brush it aside.
Yeah, so in an exam situation, I think I would go by your line of argument that to the extent that the Supreme Court is the body mandated to interpret our Constitution, and to the extent that the Supreme Court hasn't given any interpretation to the person as used in Article 3, then by extension, the interpretation of the Supreme Court as used in Article 2, which refers to a citizen, will apply. However, I would also make the argument in an exam situation that this calls for an interpretation of Article 3. And maybe as a country, it's about time we seek interpretation of this particular provision at the Supreme Court. And so that would be my final conclusion.
Okay, all right, thank you. Yes, any other? And, we have just about 16 minutes to end.
My Lord, good afternoon.
Good afternoon, Richard.
Yes, please, concerning the question. If you go to the Article 3, Clause 5, now it comes down to say any person or group of persons who suppresses or resists the suspension, overthrow, or abrogation of this Constitution, as referred to in Clause 3 of this article, commits no offense. So, for me, so long as it did not say any citizen, or it didn't say pursuant to Clause 4 above, but it said any person or group of persons. From my point of view, I'll go by the literal meaning, any person or group of persons. So I will not restrict it to citizens.
No, but you see, the difficulty is that we have the law, we have a rules on interpretation, we have the Interpretation Act and all that, okay? And for that matter, where a word in the same enactment, a certain interpretation has been given, there's what we call the presumption of consistency. Then that meaning which has been given to that word will presume to apply across that enactment, unless an argument can be made that for certain reasons, context should come in, and then where context comes in, the meaning which was given to the word should just be limited to the particular context. So as in let's say Article 2, they say that it's just limited there. Otherwise, why will you interpret a person in Article 2 as referring to a citizen, both natural and juristic, okay? And then where you meet person in other parts of the Constitution, you say that, well, it means a person as a person, regardless of nationality, as it were. But as I said, it is very open question, and then not until we have the authoritative pronouncement by the Supreme Court on it, all of us will be entitled to suggest some creative interpretation as we are seeking to do currently. Of course, I mean, I don't, assuming you are writing something like this in an exam setting at this stage, all that matters is for you to demonstrate awareness of the fact that a person has been interpreted by Supreme Court before in relation to Article 2. And then you also demonstrate that if we are to look at the, what do you call, the purpose of this whole Article 3, what is seeking to achieve, you like to probably go a step further than what was done with respect to Article 2, and probably say that if the objective is to restore the constitutional order, then it doesn't really matter whether it was a Ghanaian or a non-Ghanaian who helped to actually restore the constitutional order. And I think that you'll be within whatever masking scheme anybody is using. Okay, any other?
Yes, sir. In addition to the question under discussion, so what would be, my question is, in respect of Kelsen's pure theory of law and the position of the Supreme Court in the Equam versus PNE, what would be the relevance of Clause 5 in this context when the proclamation of the people who may have succeeded under Clause 3 to overthrow the Constitution, their proclamation then becomes the ground norm? Me, in an attempting to restore this Constitution, am I not also overthrowing another ground norm within this context? So then what will be the legal effect of Clause 5 in protection of me or any other person who tries to restore this Constitution?
No, but before you go, did the Supreme Court actually use Kelsen theory in Equam versus PNE?
No, sir, that is not my point. My point is that I'm trying to juxtapose all of this. I mean, the Equam versus PNE, the argument was that the PNE had sought to overthrow a government, I mean, which has to do with the security of the state. So that was the argument. And PNE's argument was that particular government was an unconstitutional government. So now my point is that, my question is that within that context, if someone has overthrown the 1992 Constitution, and then they have made a proclamation, minus Equam versus PNE, but within the Kelsen's theory of law thing, when the new proclamation comes, then it becomes the ground norm, then it becomes the main law. This one is done. Now, so within this context, if I try to now overthrow that particular norm, then as was said in, for instance, Equam versus PNE, that it is still a legal government, how would the Clause 5 in Article 3 be a protectionist legal provision in protecting the person who tries such an activity?
Okay, now, thank you. To start with, let us remember that Kelsen's theory of discontinuity, in which it was about like the group norm and all that. It is just a theory, okay? We have not, at least as far as our jurisdiction is concerned, our jurisprudence has not endorsed it. And you remember if you remember the Salah versus Attorney General's case, that was the first time the Kelsen's theory was actually given full consideration in the course of legal submission before the court, if you remember, and where the court actually ignored the invitation and said that that was not really what the point. So I want us to remember that Kelsen's theory has not been given a judicial blessing in our country that it is actually true. No. And if anything at all, the fact that we have Article 3 of the Constitution, I think I've made this point in one of the sessions. The fact that we have Article 3 of the Constitution is a tacit rejection of Kelsen's theory. That is implied rejection of Kelsen's theory. Because Kelsen's theory talks about the success of the revolution, and that the revolutionary maker or whoever be behind it, they become like the group norm, the basic norm, from which all other substituting norms will derive their validity and all that. But if we look at Article 3, as you rightly stated, and we'll be discussing it, you will notice that Article 3 actually encourages continuous rebellion against any overthrow of the Constitution until the rebellion has succeeded in restoring the constitutional order. And if that is so, Kelsenite group norm will not be applicable. Okay?
Yes, sir. Yes, sir. Thank you so much. This has been very helpful.
Any other question? We have about 6 minutes to go.
Your Lordship, please, the last question.
Okay.
And please, how would you resolve
Alina, before that, we didn't get your comment on the discussion we did in respect of your answer.
And please, I was also of the opinion that there should be a purposive interpretation of persons in respect of clause 5 because of the arguments that you made. Because if we were to limit it to just citizens, that means that any other person that contributed to the restoration of the Constitution would run at sort of like a loss, and that would be sort of unfair to them as a result of the contribution that they had made to the restoration. So I was thinking that a purposive interpretation would be used to
all right, before
the effect that.
Okay, thank you.
Yes.
Before Lynette, you go on with your substantive follow-up question, maybe let me remind the participants that my former boss, Professor Lydia Inkansa, who was the dean before I became a dean, she did an interesting paper, which is the right of resistance and the defense of Ghana's fourth constitution. And I think that within that paper, she commented extensively on Article 3 of the Constitution. So the paper is available online. I will push it on the platform so that if you're interested in reading more about this, you can read it as well. All right. So continue, Lynette.
Yes, please. So as I was saying, I'm of the opinion that a more purposive interpretation should be applied such that it would be beneficial to all persons, being it citizens or non-citizens, who contribute to the restoration of the Constitution, would not be deprived of the compensation that would be awarded under clause 7 of Article 3. Please.
Right. Thank you. So now what is your substantive? I think you wanted to say something.
Please, my last question is, yes, please, in respect of how the controversy of the death penalty being removed for some offenses and still remaining for others, how would we resolve that? Because it's from the recent amendments, the death penalty has been removed in respect of murder and genocide, and I think another one I've forgotten. But then for high treason and treason, it still remains. How would you resolve the looking at theories of punishment? How do you resolve leaving the death penalty for high treason and treason, but then removing it in respect of murder and genocide?
Oh, I think we've also considered this before, but what you ought to remember is that the death penalty as a punishment for treason and high treason in the Constitution is an entrenched provision, okay? It's an entrenched provision. And if you go to the Constitution, I mean, that's the chapter 23, I think, yeah. 23, no. No, that's a chapter 25, right? If you go to Article 25, sorry, chapter 25 of the Constitution, you will notice that Article 290 clause 1, paragraph A mentions Articles 1, 2, and 3 as being one of the provisions which are entrenched. You know, entrenched provisions, its amendment is quite elaborate and laborious, and it will have to include referendum. And that is why Parliament could easily scrap death penalty from the Act 29, because that is just ordinary legislation. But where it is part of entrenched provision of the Constitution, you need to go through referendum. And so that explains why it still remains. And another argument will also be that, of course, to discourage, you know, one would argue that even regardless of the difficulty in amending entrenched provisions, there's still good reason for death penalty to be retained in our on our constitutional tablet for a limited purpose. That is, those who may want to overthrow the Constitution, those who may want to wage war against Ghana. If you indulge in any of those things, we should be able to also take away, and see, it's supposed to have to go like a deterrence effect. Although argument to be made that part of the argument for abolition of death penalty as a punishment for murder is the ineffectiveness of the deterrence effect. That yes, despite the fact that it is there, we still get people committing those offenses for which is punishable by death. So therefore, if you are saying that death penalty serves as a deterrence, it has not actually achieved what its effect. And if that is so, shouldn't be the same for treason. Well, an argument will also be that the fact that you've had 30 years of constitutional order, and it's just recently that we have this ongoing trial. If you remember, those who were trying to do this secession thing, if you remember some, I mean, it's a sub judice, so we cannot discuss it. Yes, yeah, it's sub judice, still being tried, so we cannot discuss it on this forum. But at least it is just indication of the fact that, I mean, since 7 January 1993, we haven't had, I don't think you had, apart from this, that you've had any case of people trying to do anything which may probably be treated as a treason or to try and subvert the constitution and all that. So an argument would be that having the death penalty for such conduct has actually been effective in deterring or discouraging people from even daring or attempting to do that. Yeah, so that is it. Lynette?
Yes, please, I understand. Thank you very much.
Okay, so there being no substantive question and it being 12:42, I will sign off, and God willing, tomorrow I should be able to get back with you before you go and write your exam the following day. But you're on the platform, so if anything at all, you can WhatsApp me and then we can look at it. Right, so, is there anything in the question? Okay, so somebody has asked a question. How should one attempt answering a question on LGBT in regards to the proposed parliament? Also, how should you go about a question on abolishment of death penalty? Okay, I think for death penalty, at least we've said something about it, isn't it? So if you have like a question on abolishment of death penalty, if arguments are being invited for or against, that we know, as I said, be structured. In terms of the material, we have the materials there already. So just be structured and put your thoughts well. You are a law student. Don't be emotional. Just look at things as they are. And then the LGBT. Yeah, somebody asked a question. How do we answer a question on the LGBT in regards to proposed bill by Parliament? I think the last year, somebody asked this question, and then we discussed it in one of the recordings. And I also referred you to Professor Ramona Tukuba's article on LGBT in relation to Act 29. So please go back to those recordings and then play them. Okay, is there any other thing? I think that is all.